The Canadian government has been pushing really hard for a bill to regulate online streaming platforms that I think has some significant defects. While trying to go after and regulate the big foreign online streaming platforms like Netflix and Disney+, they're pulling in user-generated content from YouTube, TikTok, Instagram, and others into this regulatory quagmire. They're regulating those platforms because they know they'd never get away with directly regulating the people who make content on those platforms. This has major freedom of expression and privacy consequences. Hi, my name is David Fraser. I'm a privacy, internet, and technology lawyer with the Canadian law firm McGinnis Cooper. As you might have guessed, I'm also a YouTuber. I also teach internet and media law at the Schulich School of Law at Dalhousie University. In this channel, I try to provide educational and informative content about Canadian privacy and technology law. You should check out the full disclaimer below, but you should know that I'm about to give you a very high-level overview of a pretty complicated and nuanced subject. Bill C-11 has a lot of parts, many of which I'm not going to touch on. I'm an online content creator. I provide legal advice to other online content creators. I also provide legal advice to companies that host content created by online content creators. So all opinions expressed in this video are mine alone and should not be attributed to my firm or any of its clients. I'm a YouTuber. I'm a Canadian content creator. I'm here in the best part of Canada making videos about a Canadian subject. Like many Canadian YouTubers, I'm concerned about the effect this bill will have on a thriving ecosystem that allows Canadians to express themselves to a potentially global audience. Unless you found this video from my blog, my Twitter, my LinkedIn, you found this because of YouTube's recommendation system. If C-11 becomes law in its current state, that recommendation system may be co-opted by Canadian regulators who get to choose what shows up in your suggestions. Before I get into the details, let's talk about what Bill C-11 is, what it's supposed to be about, and where we are in the process. The Canadian broadcasting system is complicated and incredibly bureaucratic, hyper-regulated. Currently, its focus is almost entirely on linear television and tightly controlled in favor of Canadian ownership, Canadian control, and mandates for Canadian content. Though linear TV is the subject of this hyper-regulation and their expressive activities that are protected under the Charter of Rights and Freedoms, that can be justified because originally the airwaves were scarce. The government doled out places on the dial to licensed broadcasters subject to a whole bunch of conditions. But we're no longer in an era of scarcity. We're in an era of supreme abundance of possible content. The Canadian TV networks are declining. Fewer eyeballs are watching linear television. To the extent that people are still sitting on their sofas watching a big rectangle, they're watching things that look like television programs on Netflix, Disney+, and other online streaming services. So the Canadian TV networks are trying to compete against these non-Canadian services. But the Canadian TV networks are subject to huge regulation and Canadian content requirements. They have to pay into Canadian content creation funds. The non-Canadian services do not. So they want to level the playing field, which makes some sense. Personally, I'd like to see a much larger rethink of broadcasting policy when there's not much actual broadcasting going on, but the approach chosen is to subject all streaming services with viewers in Canada to the same hyper-bureaucratic regulation system to, quote, even the playing field, unquote. So the government introduced the Online Streaming Act, called Bill C-11, in Parliament on February 2, 2022. Since then, it's gone through first reading, second reading, referral to the Standing Committee on Canadian Heritage, third reading, and is currently being considered by the Senate Standing Committee on Transport and Communications. The government has said that the purpose of the legislation is to bring the huge international streaming giants into Canadian broadcasting regulation so they will contribute to the creation of Canadian content and to the promotion of Canadian content. They have said it will not affect user-generated content. Now, either they don't understand their own legislation or they're lying. The bill contains some window dressing to make you think that user-generated content will not be affected, but it is just window dressing. Here's the thing. In its current iteration, the bill allows the CRTC to require that platforms prioritize certain content that it believes is Canadian. This is called discoverability. What does it actually mean? Many people who watch user-generated content rely on the platforms to understand the viewer's interests and the viewer's tastes in order to recommend specific content to them. Some may do this very well, and some may do this less well, and consumers will choose the platforms that are better at it. But this is the Government of Canada telling a platform what they need to show. If you force the prioritization of certain content in the feed, for example, you are inevitably deprioritizing somebody else's content. And if they have to prioritize a piece of content because it's Canadian, that has nothing to do with the quality of the content or how much the viewer may actually be interested in seeing it. Whether it's from Canada is likely only one aspect of that piece of content. Almost no attention has been given to the freedom of expression rights of the platforms. It's pretty fashionable to bash tech companies and to ignore their interests. But user-generated content is one of the most expressive activities on the internet and is inherently protected by Section 2 of our Charter on Rights and Freedoms. Telling somebody, whether they're a technology company or not, what they can and cannot show, or what they have to prefer and prioritize, or how they have to show it, this affects their charter-protected rights to express the content on their platform however they like. Of course, that also affects the freedom of expression of content creators. The Canadian Charter of Rights and Freedoms protects your freedom of expression from regulation or criminalization from the government. Ordinarily, a private platform like TikTok, Instagram, Twitter, or YouTube can promote or demote your content to their heart's desire without engaging the Charter because they are not the government. But when the government requires them, by law, to promote or demote my content according to whether a Canadian regulator says I am sufficiently Canadian, directly engages my charter rights. In this case, the government is not saying whether or not I can speak, but they're saying whether or not I will reach an audience, or how I get to reach an audience. So any statement made by any advocate for this bill that freedom of expression is not implicated is either mistaken or flat out lying. One element that's often forgotten in the conversation is that expression is a two-way street. Canadians not only have the right to express themselves, but that same charter right protects seeking content that is expressive. This is the government putting its thumb on the scale, directly influencing what you, as a recipient of expressive content, are likely to receive. If the CRTC were to say that I'm not Canadian enough, or if I decline to go through some onerous process to get licensed as a Canadian content creator, the net result of this bill is that you will be less likely to be suggested to see my content. Also, largely ignored in this are the privacy implications. Figuring out whether a viewer is in Canada or needs to be shown CRTC mandated content actually involves collecting and using personal information about each and every one of the viewers on the platform, regardless of whether they're in Canada. Figuring out whether a content creator or whether a video is Canadian enough involves the collection and use of personal information. Frankly, it's none of the CRTC's business. And do you actually think that the amateur folks who make TikTok videos, YouTube videos, Snap and Instagram stories are going to fill out all this paperwork? Of course they're not. Any process to determine Canadianness will involve sensitive personal information and will create friction that's simply not necessary. And if you have to prove you're Canadian to be promoted to your compatriots, that has serious privacy implications. This week, the Privacy Commissioner of Canada appeared before the Senate Standing Committee on Transport and Communications, but it was actually pretty underwhelming. Not much was usefully said to highlight the additional collection and use of personal information that would be required to implement Bill C-11. A lot of the discussion focused on what data platforms will have to report to the CRTC, which is intended to be only aggregate anonymous information with minimal privacy implications. What's the solution to all of this? It's simple. Amend Bill C-11 so that it does not and cannot apply to user-generated content or to platforms or services when they present user-generated content. The government has repeatedly said that they didn't want to capture user-generated content, but I think that's less than truthful since they've done absolutely nothing to fix this very easily fixable problem. One final note to end on, which highlights some other issues with C-11. Maybe you've heard of a streaming service called BritBox. BritBox is an online digital video subscription service founded by the British Broadcasting Corporation and the British ITV network. It carries British television series and films. Its whole reason for being is to disseminate British content. It is popular in Canada, and it would have to register with the CRTC and make itself subject to Canadian regulation. I'm not sure how you can make Canadian content on BritBox more discoverable when there isn't any Canadian content there, and requiring it to carry Canadian content would be contrary to its inherent purpose. I'm afraid that many foreign streaming operators will decline to go through the whole registration process and will simply not make their services available to Canadians. And that would be a huge loss. Also, when we think of user-generated content, we're usually thinking of YouTube and TikTok. But there's a whole other segment of online content delivery that is aimed at adults. And they fit within the categories for regulation under C11. Will OnlyFans, Pornhub, and ManyVids have to make Canadian porn more discoverable? My concerns about the privacy of creators and viewers are even more acute when you're talking about this category of online streaming. Anyways, I think Canadians should take a close look at C11 and what's being said about it. And then think about who's saying it. Think about whether you, as a consumer of user-generated content, want your suggestions and your viewing options to be dictated by bureaucrats in Ottawa, rather than the providers who want to show you what you want to see. I hope this Canadian content has been interesting and useful, whether you're in Canada or somewhere else. I try to put out a new 100% Canadian video every week or so. So if you're interested in this sort of Canadian content, please click the like and subscribe buttons. Also, leave a comment if you have any questions or if you have any suggestions for other Canadian topics to cover. And of course, feel free to share this with anyone who you think may be interested in hearing about developments in Canadian tech and privacy law. Thank you very much for tuning in.